This is Hindsight Radio.
I represent it.
The information station changing the nation. Peace to the gods. You're listening to Hindsight Radio.
Peace, everybody. This is akiemel from Hindsight Radio, the information station changing the nation. This morning I wanted to make a video for you guys on unsworn statements, unsworn exhibits that lawyers use in their paperwork to get wins or get default judgments against you. And I'm going to show you how they can't do that. And the upper courts have upheld that they cannot rely on these things. But because of your lack of knowledge, you have allowed them to get away with these things. You haven't challenged them. The court is just not going to give you a win. You have to challenge that evidence. Okay, and I'm going to talk briefly about this and read some cases that show you have remedy in stopping these types of lawsuits from getting through. But first, my website is akiemel.com. You can go there and you can see all of the different products that I have available to help you out in different situations to get yourself to freedom. Also, my blog is blogtalkradio.com/hindsight2020. There I have a show on Tuesday and Thursday at 7 p.m. Eastern time where I talk on the air and I answer questions once I'm done talking. Also, I started something new where if you email me your questions, I will answer them on the air. Okay, so you could send your questions to this email. It's akiemel@protonmail.com. 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 So you can send your questions there. And the only way you're going to get your answer if you're listening to my show, 7 p.m. Eastern time, at blogtalkradio.com/hindsight2020. You can listen to my show and you'll get your answer. Of course, I can't get to everybody's questions in one show sometimes, depending on how many questions I get. But if you're listening, you'll get that answer. I do not really answer questions on YouTube or Facebook. It's just too much work. I get these questions, people send them there, and it's me going over to Facebook to look at questions, me going over here to look at questions. Just send all your questions to that email address, akiemel@proton.mail, protonmail.com. I'm sorry. All right, let's get on to this. Why am I doing this video? Why am I talking about unsworn statements? Okay, the biggest problem people have is foreclosures. So a lawyer comes in and he's suing you for your home, right? He's suing. And in his complaint, he's stating that you owe this bank money, you're doing this, you're doing that, and he goes down a list where you signed a contract, a note, a mortgage with the bank for either 15, 30 years, and you're going to pay them back. They go through the history of the loan, right? So he's stating all of that as facts. I'm here to tell you none of that is fact. It's just allegations. He's alleging that you did that. They are required to back all of that up with sworn statements and sworn testimony. Okay? So until he does that, all of that is unsworn statements, unsworn testimony, unsworn exhibits. Someone with firsthand knowledge has to say that that is accurate under penalty of perjury. All right? But because we took out this loan, we kind of give them an out by agreeing to it. Now, the usual tack that people take is, oh, you didn't lend me any money. Where's the note? Prove I lent you lent me money by getting this note. and all other types of tactics that I would consider being this movement. Some call it the sovereign citizen movement. I'm not part of that. I don't agree to most of their tactics because I see people getting in trouble, go to jail using these tactics. And I have never, ever seen anybody win their house with these methods. Challenging the note, challenging, oh, they don't have the note because it went into this trust. All of these things. Listen, law is precise. And law can be simple if you just know how to attack it. You have to understand what really is evidence. And most people don't know what evidence is. What evidence is the court going to consider? So you got to go to your jurisdiction, your court, and ask them, okay, what do they consider evidence in this jurisdiction? In most jurisdictions, I would say all of them, for something to be considered evidence, it has to be testimony from someone with firsthand knowledge. And if they're going to use a sworn statement, it has to be sworn under oath. If they're going to use exhibits, that has to be done under penalty of perjury. Someone has to verify it because you, who are being accused, have the right to face your accuser and question them on that evidence. But guess what? When you go to court, there's a lawyer standing over there. There's no one else with them, making all of these false claims against you without someone there to back it up. You don't know this lawyer. He's just a third-party debt collector. Are y'all getting my point? Okay, now I could go and pull up all the laws and show you, okay, this is what they require in this jurisdiction, but I'm not going to do that. I'm just going to read the case laws and tell you what the Supreme Court, for this particular case, Willer versus Johns Manville Corp., the Supreme Court of Pennsylvania says, in this case. Okay, let's read it. We're not going to read all of the top part. I'm going to scroll down. And we're going to get to the meat of the case. Okay. This is an asbestosis case. Plaintiff Albert Willer brought suit against the customary panoply of defendants, alleging that he contracted asbestosis as a result of being exposed to asbestos dust while working with and around defendants' products at the Philadelphia Naval Shipyard. Trial court granted summary judgment to the defendants' appellees, number 476, on the ground that the statute of limitations had run. Plaintiff appealed. On appeal, Willer contends that the court erred in finding there was no genuine issue material fact on the controlling question of when he acquired sufficient knowledge of his injury to start the running of the 2-year statute of limitations. He further argues that the 3-part test first stated in Volpe versus Johns Manville Corp. For Philadelphia County Reporter 290, 1980, is not the correct test for determining when the statute begins to run. That the court improperly considered unsworn exhibits as part of the record on summary judgment, and that the court erred in failing to find that appellant was the victim of continuing tort. For the reasons stated below, we reverse and remand the trial. See? This case says they use unsworn exhibits. And the trial, and guess what? They agreed. But let's keep reading, because as I'm reading, you could take excerpts out of this and put it in your motions. And I'll tell you what type of motion you can use in this case. We shall address first the question of the test to be applied in determining when the limitations period begins to run. At the time the instant appeal was taken, the controlling statement on the issue was found in Volpe versus Johns Manville Corp. For Philadelphia County Reporter 290, 1980. The Philadelphia Court of Common Pleas therein held that the statute begins to run when the plaintiff knows or reasonably should know the injury. Number 1. 2, the operative cause of injury. And 3, the causative relationship between the injury and the operative conduct. Appellant argues that a better formulation of the test was stated in Nolan versus Johns Manville Asbestos 85, number 3, 2nd, 161, 169, 71, 52, 3, December 1st, 5, 421, NE. I'm not going to read all that, those numbers. Where the Illinois Supreme Court held that an asbestos plaintiff's cause of action accrues when the plaintiff knows or reasonably should know of an injury and also knows or reasonably should know that the injury was caused by the wrongful act of another. Volpe was affirmed by this court en banc, Volpe versus Johns Manville Corp. 322 PA Super 13470A 2D 164 1983. 1 month later, though, this court rendered another en banc decision, Cathcart versus King Industrial Insulation 477324 PA Super 123-471A 2D 493 1984, in which we held that the Volpe test was too complex and adopted instead a two-part test modeled on Nolan. Because of the close proximity of these two conflicting decisions, there has ensued some disagreement as to which is controlling. See Barati versus Johns Manville Corp. 334 PA Super 336 482 A2D 1067 1984. Majority favors Volpe formulation. Dissenting opinion argues that Cathcart is controlling. We believe that Cathcart should be followed because it is the most recent holding of the court en banc, and Barati, as a panel decision, cannot overrule the court en banc. See also Price versus John Manville Corp. 336 PA Super 133 485 A2D 466 1984, applying Cathcart. However, our decision to reverse would be the same whichever test is applied. See, although the appealee, the appellant, what they're saying here is even though there were some other issues here based on the test, they would have reversed this anyway because of the unsworn affidavits or exhibits. The instant action was commenced on September 5th, 1978, and granting appealee's motion for summary judgment, the trial court found that the record established that appellant knew he had contracted asbestos as a result of exposure at the Philadelphia Naval Shipyard no later than August 8, 1974, more than 2 years prior to commencing suit. The court based this decision on certain medical records which were attached as exhibits to the motion for summary judgment. A workers' compensation claim form. Likewise, attached as an exhibit, the appellant's deposition testimony. Appellant attacks the trial court's reliance on unsworn exhibits, arguing they are not properly part of the record on summary judgment. We agree. You see that? They agree. Under PARCP 1035, the record on summary judgment includes the pleadings and any depositions, answers to interrogatories, admissions on file, and supporting affidavits. And Herrera versus Scepter 231 PA Super 508 331 A2D 705 1974, we held that such unsworn exhibits and documents not complying with Rule 1035 may not be considered part of the record on summary judgment. So what they're saying is they got in Philadelphia Rule 1035. Let's look up Philadelphia Rule 1035. PA Rule 1035. Let's hope we can find it really quick. This is the rule. Motion for summary judgment and especially a motion for summary judgment filed. Okay, that's the actual. Let's see what this. Let's click this. PA Rule 1035. It's. So they're going to make it hard for me to find that baby. Okay, let's go back and see if we can click another link that gives us a better 1035. Did that one. Let's see this one. How this is going to come up. See, when you click them, it doesn't give you. Okay. Y'all get the point. I try to pull it up. Philadelphia is going to take a little work. I can definitely find it, but I'm not going to hold up the video for that. Whenever you're studying things, go look at these rules and see what they say. Especially in your jurisdiction, you want to look at the rules, right? All right, so what they're saying is they have to follow this rule. And unsworn exhibits is not a rule. Guess what? When you get a foreclosure, they don't have anybody swearing to the facts of the case. It's the lawyer submitting the evidence, saying, okay, we got this off the record. We saw this filed here. This person swore to this and did the transfer, or the, what do they call that? Assignment of mortgage. All of these different things they have in there, but none of them are sworn to. And judges every day are giving these lawyers, these attorneys, wins off of unsworn exhibits. And you guys are not challenging them on that. You're not doing a motion to vacate judgment because the court relied on unsworn exhibits as the basis of its decision. Oh, I just gave you the template. There it is. And it don't have to be a long document. A lot of y'all like to write 2-3 pages and give out, way too much information. Just a simple, hey, the court relied on unsworn affidavits. You can prove that. Why? Because they did it. And just in case they, that court, okay, let me just tell you this. You have to go to that particular court and do that motion to vacate the judgment and get them to either give you the win or deny you. Then you appeal it up to the higher court. And they will give you the win if there's unsworn statements. Don't put a bunch of other stuff in your paperwork that they have to look at. No, just use that one thing. Why everybody texting me this morning while I'm making my video? Anyway. All right, let's keep going. All right. Appealees argue that the documents should be admitted, although unsworn, because they nevertheless meet 3 criteria supposedly stated in Herrera. This argument is based on a misreading of Herrera. The criteria cited by appealees are part of a quotation in Herrera of PARCP 1035D, which does not create an exception to the rule that unsworn documents may not be considered. Rule 1035D simply specifies requirement which an affidavit must meet to be considered on summary judgment. The rule still clearly requires that the documents in fact be affidavits. The medical records and other documents at issue here are not affidavits. Therefore, the court erred in considering these documents and ruling on the appealee's motion for summary judgment. It says here, let me read that again. The rule still clearly requires that documents in fact be affidavits. The medical records and other documents at issue here are not affidavits. So just simply pulling a record is simply not an affidavit. Someone has to write an affidavit saying such and such happened, swear to it, sign under oath, then attach the record saying these records are authentic. Just like you would go get an authenticated document to put into your case to support it, you have to write an affidavit in support of that evidence saying, hey, I'm entering this and this came from here. Boom, put it in your case. Therefore, the court erred in considering these documents in ruling on appealee's motion for summary judgment. However, our inquiry may not stop here because the court also based its decision on appellant's deposition testimony. In his deposition, appellant was questioned extensively about statements he admitted making in his own handwriting on a workers' compensation claim form. He admitted he had written August 8th, 1974 in 2 places on the form. As one, the date he first became aware of his illness, asbestosis, and 2, the date he first realized the illness was caused or aggravated by his employment. Appellant attempted to explain that he did not actually know he had asbestosis on August 8, 1974, and wrote that date on the claim form only because his doctor told him to. In the course of this discussion, the following colloquy ensued. Question. Okay, what were you told by the doctor? A, on August 8th. Question. On August 27th, 1976, A, that I had asbestosis. Number 479. Question. And as to this date, August 8th, 1974, is that the same conversation you had with Dr. Duca? A, yes. Deposition of Albert Willer at 104-05. I'm not going to read all of that. First, listen, y'all get the point on this. I want to go to one more case before I shut this down. Let's go to Brown versus Michael D. Brown, Esquire Appellant, versus the School Board of Palm Beach County. This is out of Florida. And we're going to skip on down. I already got it highlighted. It says in here, this is for Leon Schaefer Goldnick Advertising Inc. versus CEDA. I read this on the E on My show last week. In this case, the trial court improperly relied on the unsworn statements of Brown and Horowitz in making its decision. Accordingly, we reverse the trial court's decision and remand for further proceedings. Y'all get it? Are y'all starting to get the point? Are y'all starting to get the point that these lawyers cannot use unsworn affidavits, unsworn statements, which most 99.9% of the time, they're in front of the court doing all the talking, making allegations against you without first-hand knowledge. Here it is again. Let's look at this part of it. The same case. I don't want to do that. Just want to highlight where I'm at. An attorney's unsworn statements do not establish facts in the absence of stipulation. They're telling you that they have to do stipulation, meaning they got to come to you, and you guys got to come into agreement with what you're going to allow him to say in court or put into evidence if it's not going to be sworn in. Trial judges cannot rely upon these unsworn statements as the 1270 basis for making factual determinations, and this court cannot so consider them on review of the record. If the advocate wishes to establish a fact, he must provide sworn testimony through witnesses other than himself, meaning other than the attorney, or a stipulation to which his opponent agrees. So, like I just said, they have to agree. Okay? Here it is. The alleged facts of this case were presented by both sides at the evidentiary hearing held on April 22nd, 2002. This hearing, which resulted in the trial court sanctioning Brown, was dominated by the unsworn testimony of attorneys, Brown and Horowitz. At this hearing, the attorneys did not make any stipulations as to the facts in this case. See, this right here is so hard to get people to understand because they keep going in and listening to people and these so-called gurus. Oh, challenge the no. Oh, get you a securitization order. I did all of that crap. But the only thing that shut lawyers down, the only thing that ever shut a lawyer down was when I challenged their evidence and said these were not facts. His words are not facts. Who's here to testify? And I did it in writing. And when I did that, they stopped sending anything to the court. Okay, I'm talking from experience. All right? So, what I'm trying to tell you guys have to start looking for the simple solutions. All you need is this. Because they're so used to coming into court with lackluster evidence, with BS statements, that they're arrogant. See, their arrogance is their weakness. Their power is their weakness because they have the courts on their side in most of these cases. So use it against them. Okay, you want to say all this, but okay, find all of these people you claim I did business with in this mortgage and bring them in here so we can talk and swear to this evidence. Other than that, it can't be admitted. All right? And as a disclaimer, I'm not a lawyer and I'm not giving you legal advice. I'm just reading cases so that you can get educated. All right? I got to say that. So, I'm going to do a video on motion to vacate judgments soon. It may not happen for about a week or so because I got to go to a seminar coming up this week in Champaign, Illinois. Look at my other video. The details are there. It's $50 for one person, $80 for two. We're going to be going over a lot of things. Status, nationality, debt collectors. And I'm going to go in detail. By this time, I probably have my motion to vacate judgments available. All right. All right. Peace. And that's it. Once again, tune into my blog talk station, Hindsight Radio, blogtalkradio.com/Hindsight 2020. Peace.